my new webcam background. To my right, Dr. Sana Khan. To my left, Dr. Nia. Below me, Basil, and our silent partner here, the Injury Institute, by the lovely Audrey. So what we collectively here, we have basically each one of us has at least 25 years in the workers' compensation system. Myself as an attorney, Dr. Khan is an educator as well as provider of diagnostic, and then Dr. Nia over here, a reporting physician. And then Basil down below has been in the back office part of the business side of doing medical treatment in workers' comp, and provides a service both for reporting, software, for collection, and I'll let him introduce his services in a second. For my purposes, I've been doing only workers' comp since I graduated law school. My father-in-law, Mr. Gaylord, brought me in right out of law school, and I was the kind of trial by fire. Like it's 2 months after I passed the bar, I was trying cases in workers' comp, which I do not recommend for anybody, but nevertheless, learned a lot. Been doing everything from asbestos cases through complex, catastrophic, orthopedic, and multi-body system cases. Along the way, I've had the opportunity to work with both Dr. Nia and Dr. Khan, as well as become a member of and a local chapter president of the Harbor Area Applicants Attorneys Association, which is a chapter of the Greater California Applicants Attorneys Association, which is an association that provides education for workers' compensation practitioners and doctors, as well as we get the judges there, we get the defense attorneys there. Everybody comes to CAW. It's a great organization. It's a great social organization. It's also a good education place to get educated. Dr. Khan is a big proponent of medical legal education, and if you want to get into this space, knowing the business side is going to be an absolute necessity, and knowing the legal side is also going to be very important. One gets you paid, the other keeps your business going. So with that, now that you know me, like I said, I'm a practitioner here in Long Beach, California. I work primarily out of the Long Beach and Los Angeles boards, but there are boards up and down the state, so you can practice workers' comp, throughout the state of California. And with that said, I'd like to introduce, I guess, first, Dr. Khan, if you'd like to introduce yourself.
Sure. Thanks, Tom. My name is Sana Khan. I'm a radiologist. I own a company called Expert MRI. We have 25 locations currently in California, and primarily do med legal work. Was doing a lot of workers' comp in the past, along with personal injury. But due to some changes in laws and stuff, we actually started to do less and less of workers' comp. It looks like things are getting better, Tom. So I'm really looking back and saying, you know what, maybe it's time to really kind of pick that up again. But I've still kept up with the laws and rules and regulations as best I could. It's awesome. It's great to be here. And I think we're going to have a fun, we've had some good conversations already. So I think we're going to have a good hour here today.
Dr. Nia?
Thanks, Tom. Hi, this is Dr. Nia. I'm a primary treating physician in the City of Commerce, Los Angeles area. Been in the med-legal community for close to 25 years now. Obviously, I've worked closely with Tom and Sana, Dr. Khan in past. And been doing mostly workers' compensation, do some personal injury, but my main practice and my main focus has been in workers' compensation. I own a multidisciplinary practice, and we treat the patients basically from pain management, chiropractic, physical therapy, and orthopedic surgery.
Basil.
Thanks, Tom. My name is Basil Saloom. I am the President CEO of Innovative Medical Management and Connexum Software. I've been doing billing and collections in complex claims in California for workers' comp and personal injury for about 27 years. My company provides services from patient screening, billing, collections, court representation, and case management from front to back to assist you guys in getting paid. And assisting attorneys in getting information back and forth from the medical offices to streamline processes and make sure everybody's happy and getting paid and reducing cost.
Awesome. So, so where do we start, right? Obviously, the first thing is that you see a patient. So you're more than likely, most doctors are getting referrals from attorneys, whether it's PI or workers' comp. The attorneys are your primary source. I'm sure that people may come into your medical office if you run any kind of a clinic, come off the street with injuries, and they may be either work-related or personal injury or otherwise. But more often than not, you're going to get a referral from an attorney, and that's how your business is going to grow. So when a new patient comes in the door, right, what begins the process such that the work that you're going to do is going to result in you getting paid, right? So we go directly to the labor code, and I just want to share a screen with you real quick here. This is labor code 5402. It's where we start. And there you have it. So when the defendant, in this case the employer, is provided knowledge of an injury, right, they're supposed to, within 1 working day of the filing of a claim form, provide medical treatment. Okay, so what does that mean? Well, the patient's supposed to get, in this case in a work comp claim, if they're injured, they're supposed to get a claim form. The employer is supposed to provide a claim form. That claim form is filled out. The applicant, in this case, gives a short definition of how their injury occurred and what body parts they're claiming, and they give that to their employer, and at that point the employer is supposed to send them to a doctor. Sometimes they do, sometimes they don't. Sometimes they accept the injury, and sometimes they do not. Either way, that begins the clock for the 90-day period for them to accept or deny the case, delay or deny the case. During that period, that first 90 days, if the case has not been accepted or delayed, there is a period of time where it says in paragraph C there, that up to $10,000 of medical treatment shall be, up to $10,000 shall be paid and shall be provided until the case is denied or delayed. So there is your window for your med pay. There's your window to get paid on a case. Doesn't matter whether it's accepted or denied up until that point. So once it gets denied, that window closes, and then we move into a different part of the claim. But that's your, I guess, sweet spot. If Basil can help you with that one. Basil, would you concur?
Yeah, so if I can add to that, you know, one of the reasons that we wanted to hold this seminar today specifically for doctors that are doing PI, and I'm not sure how many of you guys have done work comp in the past, or this is the first time you're going to be doing workers' comp, but you know, in 2013, California passed a Senate Bill 863 that pretty much scared the hell out of everybody who was doing business in work comp at the time. It was something that people didn't really understand very well. But it turned out that this Senate Bill 863 was really a blueprint that the state issued that actually lays out a roadmap for medical providers to be very successful very easily, okay? The Senate bill basically says that you have to request treatment through an RFA, and you have to write medically necessary reports. The patient's entitled to get $10,000 worth of care in the first 90 days until the insurance company accepts liability, which at that point, like Tom said, they would continue to get care and get paid, or they deny the case. Now, if they deny the case, the physician who's treating that patient can still continue to treat that patient. More than likely, the provider will end up filing a lien. But in our experience, and like I said, I've been doing this for 27 years, This is the easiest time to get paid in workers' comp because we have that blueprint that says this is what you need to do. If you're submitting your RFAs properly, and it's a state mandated form that's very easy to fill out, it requires you to request treatment that is considered MTUS compliant. That's the standard of care that California has adopted for course of treatment. My company does provider education. We come on site, we meet with the doctors, we show them how to write these RFAs. I actually created a software called Connect Some Software, which we referenced earlier. All of these forms are built in. So utilizing that platform really streamlines the process. But providing these RFAs to the insurance companies and writing medically compliant reports will almost guarantee that you're going to get some form of payment on these cases when the case settles. Now, the big deterrent, 7-8 years ago was these work comp cases would last 4, 5, 6 years. Medical providers would have to wait a long time to get paid. But since the adoption of SB 863, what happened was these MTUS treatment guidelines for probably 90% of the cases have the lifeline of these cases about 18 to 24 months, which falls in line pretty much with what you guys are already doing on your PI cases, right? You get a PI case, there's some med pay, probably not a lot. You're getting the majority of your money at the end of the settlement of that personal injury case. Well, work comp is pretty much the same now. Because these cases are being tried and settled within 18 to 24 months, you're going to have an opportunity at the end of that case to negotiate and get your bill paid, which obviously is what my company does on your behalf. And by the way, our services are no charge up front. It's contingent on the back end only. If we don't collect, you don't pay. So there's not a whole lot of investment up front to get into this space. You basically are going to treat the patients like you're doing it now, with some education and modification on reporting to make sure you're addressing some key things that the medical reports need to indicate. But the benefit on the work comp side with this 5402 $10,000 money is if you're the primary doctor, the first doctor who's seeing this patient, and in most cases you will be, you're going to get to take advantage of $3,000, $5,000, $6,000 of that $10,000 before the insurance companies determine liability. So you can actually build cash flow quicker doing work comp versus PI and still have that account receivable on the back end at that 18-month mark to get that big chunk of settlement on the back end. So my belief is this is the best time to get in. There's a huge demand for medical providers in the work comp space. Most of the doctors that were treating work comp when SB 863 came in went away. But getting into it now without having been in it for the last 20 years and not knowing how great it really was back in the day, getting in now is as good as treating PI cases, right? So with the right team, the right support, or at least the right education, you can build a very comfortable cash flow and add that to your existing PI business with almost no out-of-pocket capital. I mean, you're already there treating patients. You're just going to plug in these work comp patients, and a company like mine is going to step in on the administrative side and not only walk you through the whole process, but provide all the servicing that you're going to need to ensure that you get paid. So
Basil mentioned RFA, right? So there's a definition, a 4-page document that you may have been provided, should have been provided, that has some definitions of some terms you might hear this afternoon. Request for authorization. It is an actual state form, DWC RFA. Anything that a doctor requests, from an MRI to medication, surgery, anything that he wants has to go on the RFA. And then, of course, the RFA, as we know, has to be, the requests have to be MTUS compliant. And so getting your report to become MTUS compliant, you work with Basil software, but in order to write a report that answers the questions that might come up with regards to medical legal issues and treatment issues, you also want to supplement your practice with education. And that's where we go over to Dr. Khan, and he may discuss organization that you might be able to join, and as well as cause a little bit more advanced, but to get the startup education, you want to be in the organization. I believe CSIMS is where you're going to get some of that education. Dr. Khan, if you'd like to provide some information regarding that.
Yeah, so CSIMS actually has been around for 40 plus years as the California Society of Industrial Medicine and Surgery. Currently I'm on the board of directors as well as the chair for their education committee. So we are about to start a whole series on exactly this, which is the case management. So we have two-part webinar. We have two webinars going, starting within probably the next month or so. I highly encourage you guys, if you want to do workers' comp, to become part of CSIMS because there's lots of education that's about to happen. In terms of case management and case treatment. The injuries, the pathophysiology, the anatomy, the treatment, and the AMA impairment ratings are all going to be taught in one series. And the other series is going to talk about some of the subjects we're hitting on today, which is basically knowing case status and what to do with it. Meaning when as Tom was pointing out, when a patient walks through your door, what do you do? Well, I think first thing first, you really need to know the case status. Is this an accepted case? If it is, are you on the MPN or you're not on the MPN? Is it a denied case? If it's it's an accepted case for the disputed body parts, right? Is it within the 90 days of discovery? The injury happened a few weeks ago and the employer hasn't accepted or denied the case. So these statuses are very, very important, but each one essentially leads you to a different path, not necessarily treatment-wise, but in terms of case management-wise. How are you going to actually handle that case, and what are you going to do in terms of protecting how to get paid? So Tom, so that's what we're going to be teaching, and we'll be definitely getting this out to the audience and others. And by the way, this is designed for treaters as well as for attorneys to learn the medical side of it as well. And what does it take to do an impairment? What exactly is impairment ratings of the wrist, and how is that gotten? I know you guys fight about this stuff in the courts, and you argue in terms of impairment ratings and the PD, but it'd be nice for you to learn what's the medicine behind it, you know? So we're going to be doing a lot of that education, and Basil, I mean, again, I'm a big fan just from the work and amount of intense work that you have done in putting your structure and your software together. And Tom, I expressed to you the other day, somebody fresh coming into workers' comp really is going to need a lot of hand holding. But it's okay. I mean, because we have the systems that'll hold hand for you, particularly with what Basil is doing. Dr. Nia and I are already talking about potentially having teaching sessions again, like we used to do in the past. So we would be happy to help newcomers come in and try to make it easy for you.
Will Injury Institute be providing the information on those webinars? How would they find out about that?
Yeah, I mean, I know Maria really well. And so they are certainly, they do a lot of support. I do a lot of webinars on the PI side of the fence, and Injury Institute is always sponsoring those. So we're going to definitely work with them on the CSIMS side of the fence as well. And
yes, of course, we will be sure to let anyone who's interested attending this webinar know that information after the webinar. Definitely.
Excellent. Okay, so let's move to now. You've gotten some education. You've done. Hopefully, you've gone to a webinar. You've got Basil's software going, and now you get a client. He's through the door. He's filed the claim form. It's say it's a denied case, or let's say it hasn't been accepted or denied yet. You're under med pay. You're going to provide medical treatment. So what is medical treatment under workers' comp? I'm going to share a screen again and show you Labor Code Section 4600. Okay, so basically this is the, the long and short of it. So it's medical, surgical, chiropractic, acupuncture, and hospital treatment, including nursing, medicines, medical, blah, 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 required to cure or relieve the injured worker from the effects of the worker's injury, and shall be provided by the employer In case of neglect, that's the same as denial. Okay, so the case is denied or refusal to reasonably do so. That is, an employer or foreman says you're going to be okay, don't worry about it, put a Band-Aid on it, and it's a a broken bone or a torn meniscus. The employer is liable for the reasonable expense incurred on behalf of the employee in providing the treatment. So there is your sort of your labor code section that provides that the employer is required to provide medical treatment, regardless of whether they do or not. So that guy coming in your door that has notified his employer of an injury gets medical treatment. There it is. It's black and white. That's our starting point. Now, I'll go to Dr. Nia. The gentleman comes in. He's got a claim form. It may have been filled out. He may have filled it out. The employer may have filled it out. It may say he lifted something and injured his back, and yet actually he also injured his back, fell, and kind of messed up his wrist and is having some issues with his shoulders. But the only thing that the employer puts is the back, because that's what the guy's holding and that's what he's complaining about. So he comes into Dr. Nia, and Dr. Nia is going to see this and he's going to treat this guy. Now, Dr. Nia, you see this person for an initial evaluation. And what does that initial evaluation look like?
So, I mean, doing an initial evaluation in workers' comp is no different than doing an initial evaluation in personal injury case or just a regular, patient that comes into your office. You need to do a comprehensive evaluation as far as examination goes. The only difference is you also need to be able, and you need to make sure you get a good history of injury from the patient. And that would be very crucial for your success and also the help of the attorney, and make sure the attorney also has all the information needed. Exactly what happened, how the injury happened, how did the patient fell? Because I've seen it many and many times that the patient comes in, the claim form has back, but does not have, for example, a lower extremity or the right leg on it. And we know, in the medical board that a lot of time when the patient has back pain, they have radiating pain going down their legs. So the carrier turns around and denies the leg, which is really originated from the lower back. So that's why it's so crucial to make sure that you put all those body parts in. And if there is a discrepancy between what is on the claim form and what's basically the patient telling you, then you need to pick up the phone and basically notify the attorney's office. Look, I have Mr. So-and-so here, he injured his lower back, but I know that he has also a problem with his right hip that we need to address, and make sure that you amend your claim form to address the right hip so we can go ahead and start working on the right hip too as well. So the history of injury and how the injury happened, it's crucial. The past history is also very crucial, because in workers' compensation, when it comes time to PNS the patient, or permanent stationary, basically when the patient is at maximum medical improvement, we need to issue an impairment rating. And there are, I don't want to get ahead of myself and go into a lot of details, but if there are past injuries involved, be it a workers' compensation injury, be it a personal injury, be it a motor vehicle accident injury, all those needs to be also addressed. So those can come very handy at the end of the case when you're rating the patients and you're assigning the amount of basically rating to each of those injuries, which becomes very crucial for the attorney to have at the end of the case. But in general, make sure that the examination is comprehensive. The history is also comprehensive, so you can basically build your case very well from the beginning. And that will help you at the end, especially when it comes to collection and when it comes for a collection company like Basil to be able to do a better job on collection.
So thank you. So so this person comes in initially for acute trauma treatment, and a lot of these cases, as you've already mentioned, Basil, 18 to 24 months. Over a period of 18 to 24 months, the case starts as let's say the trunk of a tree, right? But it grows branches along the way. A year into using Norco, because the guy is contemplating, back surgery or knee surgery, and the person's in a tremendous amount of pain. What kinds of things do we see if they're using a lot of, let's say, multiple ibuprofens per day, and you precipitously see an elevated blood pressure reading? Is that a note to self, I need to put something in the report that says maybe he should consult an internist to see this issue. Same thing with constipation, hemorrhoids. Person's now complaining to you that this is occurring, and you know the person's on opioids with no prior history. This is, once again, this request for authorization process is not just for you to get an MRI and not just for you to get authorization for treatment, but, and I'm going to share screen real quick again, and I'm going to show you, folks, your duties, the reporting duties of the primary treating physician. If there's one code section that you're going to have to know right from the get-go, it's these duties. And the beginning of this code section basically just gives you definitions. What's a primary treating physician? What's a secondary treating physician? And the fourth number I highlight in red here because it's very important. It may look like Greek to you now, but when it says medical determination means for the purpose of this section, a decision made by the primary treating physician regarding any and all medical issues necessary to determine the employee's eligibility for compensation. Well, compensation includes medical treatment and also impairment. So in this case, if the applicant is entitled to be seen by an internist and might have impairment, gastro impairment, might have hypertension, cardiology impairment, might have any number of other specialties. Those are one, as the primary treater, you're looking at the whole person, and that's why we work with the AMA guides, which provide us whole person impairments. And there's 16 chapters in the book, each providing different body systems. You've got the spinal chapter and the everything across the board.
Upper extremity, lower extremity, yeah.
All the body systems, right? So it's important that while you start with this trunk, that as a good primary treating doctor, for purposes of being complete, doing a good job, not only for the insurance company, so they know you are being comprehensive, but also for the applicant attorney, hey, there's a consequence of this injury. Perhaps you have an overuse. The person's arm's in a sling following surgery, and all they do is use the other arm, and now that other arm's becoming, having an overuse injury. It's sort of, we need to have that included in the claim, and so that needs to go out in a report so that I know, like Sana said, I have to amend that claim. So these sections of the reporting duties are very, very important, and I go down here again to part F, and it states very clearly, F2, there is any significant change in the treatment plan, including but not limited to extension and duration and frequency of treatment, need for hospitalization or surgery. C, new need for referral or consultation by another physician in a different specialty. Okay, those things, those parts of that primary treating duties are just the most basic, but also the most important part of what you do as a primary treater. Not necessarily to get paid, but to keep your business flowing in, because guys like me, we want to know the whole person. We want to know what's going on. And I think, Sana, you may have something to add to that, but that's real important to us. So Dr. Nia, you may have something to add to that as well.
No, along the same line as you're talking about, is compensable injuries are also really big in workers' compensation. That's something that does not come up as much in personal injury cases because it's, when you see a personal injury case is, patient tells you what body parts is hurting, and you just go ahead and start treating all the body parts that's basically been injured. In workers' compensation, there are specific body parts that are being reported and accepted by the insurance companies. So if the insurance company comes in and accept the lower back, but then we know that because of the low background that this patient has been having, now they have developed neck pain, for example, or their shoulder pain or any other thing, then you need to go ahead and address those compensable injuries. And again, report it back to the attorney and make sure the attorney is aware of these body parts that are a consequence of this primary injury, and make sure that's addressed and added to the claim form, and notify the insurance company right away that, hey, there is a second injury to this, basically, primary injury that needs to be addressed. A lot of times patients go on medication, as you mentioned. They stay there for a long period of time. They take these narcotics, and they develop these GI type, symptoms that's directly related to their primary injury and needs to be addressed basically. So the patient needs a referral to an internist and work up there to make sure that all those body parts are also addressed. So it's really crucial that attorneys and basically doctors work together very closely and notify each other of their findings right away. Versus with personal injury, you probably just hear from the attorney on day one, the case is referred to you, you go ahead and treat the patients for a few months, and very rare cases it gets to that level, and then the patient basically is, at the end of the case, when you're done, you issue your report and you send it to the attorney, and then you move from there. But in workers' compensation, it's a bit more, I would say it's different because it's more paper intensive. You need to report every 45 days. You need to issue a report every 45 days. And you need to notify the parties every 45 days as to what's going on and where the patient is going with it in the course of treatment, basically.
So now, I'm sorry.
Those are billable events, right, Basil?
There you go. There you go.
Yeah. Oh, so what I was going to say is everything you guys have heard right now may sound a little overwhelming. The good news is it's not. It seems like it is, but it's not. There's resources now that are willing to come into your offices and walk you through these processes, and for the most part, assume some of these responsibilities on your behalf at no charge, right? We get paid on the back end when you get paid. So we'll put up the resources, the certified professional coders, the physician education resources, the documentation, we'll bring it all in. Tom had mentioned, my software connects them. It's a great tool, but it's not necessary in order for you to get into this space because my rev cycle management company, Innovative Medical Management, will provide all these services for you, whether you're using the software or not. Now, obviously, using the software just adds another layer of efficiency for you. And some cost savings for you in terms of labor cost and all that, but it's not necessary. So the reason that we wanted to hold this seminar is because everything that we've talked about today is important. The industry needs it. We need medical providers who are willing to get into this space. The most ideal medical providers to get back into this space are ones that are doing personal injury because they understand injury-based treatment, number one. And number two, you are looking to hopefully increase your revenue without increasing any overhead, right? Workers' comp used to be an expensive practice to run. You had to have a lot of labor and deal with a lot of different regulations and things like that. Today, we've got resources that are willing to come in and do that stuff for you. We're willing to train, we're willing to help because the industry needs good providers in the space right now. Okay, so that is the key benefit and one of the key reasons that you would want to get into the space today versus in the past, right? You don't have to walk into this thing with a huge financial investment and blind and not understanding what you're doing and make mistakes along the way. We eliminate that altogether. So if anybody's interested in learning more, obviously we can get into more details. Any one of us can get on a call, a Zoom call, email, whatever the case may be, to have more in-depth conversation. The associations are key, in my opinion. Becoming part of CAW and CSIMS is something you should do no matter what, just because of the amount of education and information and support. The support you get is vital, right? Support in not just materials that you'll need, but in patient retention, patient referral. Tom's point on this reporting stuff, which again, we will assist you in fine tuning, very efficiently. This is what's going to keep the attorney sending you guys more patients, right? You get 2 or 3 attorneys who send you 3 or 4 cases and you're writing good reports, rateable reports, medically compliant reports. Those attorneys are going to send you patients forever. Not only that, the insurance companies are going to appreciate the quality of the report, the fact that they're compliant, the fact that you're not over-treating, and they're going to pay you quicker, right, than somebody who may not have that type of support. So I think those are probably the key things that, we want you guys to take away from this is if you've thought about getting into work comp and you were intimidated by it, you thought it was a massive financial burden, or you simply don't understand it, this team here will absolutely assist in getting you guys back in. You know, Sana's MRI companies, he used to do a lot of work comp. He's doing way more PI, but I've convinced him to get back into the work comp space, which is why he's on this with us, right? So that's important, as you guys will see when you get into this space. You know, finding providers that are willing to treat is difficult. That's why we're doing this, right? So having doctors like Dr. Nia who can help, you can refer out for ancillary or whatever the case may be, however he can provide any services for you. This is what we want to do. We want to build a network of good doctors who can provide good treatment. And I think that's kind of the bottom line of what this is about.
What Sana had just about said, and I think it was, it got glossed over real quick, but that was, these are billable events. Why I mentioned the things I mentioned about how a case may grow from the trunk to a tree with a bunch of branches is that, as Dr. Nia said, it is different than PI in that these cases kind of can take on a life of their own, in that we are treating the whole person, and all of these become part of the reporting process and the referral process, referring within your network. If you have a multidisciplinary network where you have multiple doctors in different specialties that might also get business because these consequences have come up along the treatment plan, and the billable events that occur along the way of that treating and treatment process, which also leads us into, you know, when the disputes come up, how do you resolve these disputes? And what the relationship you have with me is, hey, we need to resolve this dispute. We need to get the defense involved. We need to get this case accepted. This is clearly an accepted injury. We need this surgery accepted. You give me a report that is seen by that neutral doctor we haven't talked about yet, but that panel qualified medical examiner, which is something that is going to come up in just about every case that you guys see. If you provide, as Basil said, a good treatment plan, you've documented your reports, you've been given a good mechanism of injury, and you've documented the consequences along the way, when it gets to that QME and he reads the medical records, he's going to have one advantage in that he's also going to get paid to review sometimes thousands of pages of medical records that have compiled over the person's lifetime, the prior car accident or prior work-related injury or sports injury, and he's going to see all that. But then you get to review that report, and you can be asked by the attorney to do your own medical legal evaluation, which gives an opportunity for Dr. Khan to do an MRI and get paid for it. And, you know, another doctor over here allows these people not only to become part of it, but also for you to learn more about the case and get paid for it. So, Sana, maybe you can add something to that.
I mean, I can tell you right now that for those that are, you know, if you're thinking of coming into workers' comp right now, or if you've been in the past, you're thinking of coming back in, right? It's going to require some work. But this may be one of the most interesting times to be in workers' comp. From a perspective of a practitioner, I can tell you from a medical perspective, you can really structure your practice as such that it's very streamlined to what needs to be done next. It's pretty defined pretty well by the MTUS as to the different pathways of treatment. So it's a lot easier than coming into a system in which there is no structure. There's actually a lot more structure in workers' comp today than there was 20 years ago when I entered, 25 years ago. And so I think it's actually easier for those that want to come in, as long as you're willing to learn and get educated. And Basil has this amazing MRI machine, but if I don't know which buttons to push, I never learned which buttons to push, that machine may bring out the crappiest of images because I never learned which buttons I needed to push for that machine to give the best images, right? When I'm giving you an example, that's why education is going to be very important. Learning from people that have been in it, that know what they're doing, is going to be very important. And if you're willing to spend the time and energy to do it, then it's well worth it. If you're not, don't start, because you may end up just spinning your wheel, giving out bad reports. Tom's going to look at one report, 2, 3 reports, he's going to stop sending to you because he doesn't have time to sit there and babysit a doctor on how to write good reports. But if you write good reports, if you're doing good work, Tom, right? Today's world, you're going to keep using that doctor because then the doctor will make your job a lot easier. So my point, you know, it's kind of getting on a little soapbox here, but my point is that if you're willing to make the effort, and honestly, I don't know why you wouldn't. I mean, how many years has it taken for us to go to medical school and do residency and fellowship, or go to chiropractic school and get that degree? And why wouldn't you want to read a couple of extra books? If you have to read the AMA guides, come on, read the AMA guides. I'm a radiologist. I don't need to read the AMA guides, but I did. Why? Because if I'm going to play in workers' comp, I need to know the rules. Why do I read labor codes? Because I need to know the rules, right? Why would Dr. Nia spend all this time that he does on the medical treatment utilization schedule, the TUS? Because without it, if he doesn't know the rules, how is he going to play in the game? You can't take a basketball, run across the court, and spike it on the other side and say touchdown. You're in the wrong sport. So Basil can help you significantly. We can help you significantly, I think, you know, in terms of our teaching and CSIMs and everything else. But you're going to have to put in that work. And I'm not trying to discourage you from coming in. I'm just preparing you that you can't just rely on a software. You have to rely on your knowledge and then what to do with that infrastructure.
Education is key.
Right? I mean, I think, right, if you don't have an educated doctor, no matter how good your systems are,
right,
what good is it?
We have a very interesting question from Clayton from the attorney's perspective, and it says, can an attorney do workers' comp as part of a larger practice, or is workers' comp really a field all on its own, requiring far too much specialization?
It's a very specialized area. It's a very specialized area of law. There are practitioners that dabble in personal injury, but I would venture to guess that these are attorneys that are basically handling cases, and we call, I guess in PI, it's called pre-lit, right? So it's clearly a policy limit, low policy, bad injury, real easy to settle that case. There's not a lot of money in the policy and there's a real bad injury. You're going to get a policy limit. It's easy case, right? But what happens when you have that Uber driver who gets in an accident? We know that that Uber is $1 million policy. How much of that $1 million is that PI attorney going to get? If he does primarily work comp, he's not set up, you know, he probably doesn't have the kind of resources to go to trial on a you know, in $1 million Uber claim in Superior Court, you know, that's going to take him a couple of weeks. We have to be in court almost daily. So I think you could do it within a practice. I don't think the same attorney is going to be able to do both well. That's just, I'm done very little on the PI side. I refer all my PI work. And nowadays, I think there's the referral, reciprocity and referrals is the way to go. I wouldn't think that a PI guy can come easily into work comp and do it. I would persuade them not to. They probably cannot provide adequate representation without spending a lot of time, as Dr. Khan said. The same thing applies to the doctor that applies to the attorney, but even more so on the legal side because there's so many just nuances.
Go ahead. We have another question.
Yes.
How often do workers' comp cases now go to trial? They think that they have increased recently.
If so, minorly. It used to be that maybe 2%, and now it's 4%, 5%. I still don't see a lot of trials. Cases get set for trial, but don't get to trial because they settle at trial. But actually first of all, you gotta understand, since COVID, right, for the first couple, 3 months after COVID, there were no trials at all. Now the trials are having to be done by like a Zoom trial, and they're kind of clunky. I don't know how, we've done them in my office here. I haven't personally had to do one yet. I was set for trial today. You know, you got to have your client in one room, you're in another, the defense attorney's in his office, and the judge is in court. So if you can imagine how clunky that process is, and I understand from PI, there's no court open yet. So those cases must be getting backlogged terribly. So I can't imagine what they're doing in the PI side. The backlog has got to be incredible. I don't know personally, but that's from what I understand, that's what I hear.
I also think the uptick might have something to do with the fact that the life of the case is getting shorter, right? So
Yeah.
what these cases that used to stick around for 3 or 4 years that are now, you know, being settled or tried within 18 to 24 months, the cases are moving faster. So you're seeing more cases at trial. Trial doesn't really affect the medical provider so much at this point. I mean, you want the case to end, right? Either by trial or what happens 97% of the time, which is a settlement, a compromise in release, right? A CNR, or a fine, you know, a stipulation where everybody just agrees, this is what we're going to settle the case for. The end of the case means that as the medical provider, if you haven't already been paid, now you have your opportunity to get paid and negotiate. The other thing that got shortened in the lifespan is liens getting resolved, right? If you wanted to go to lien trial back in the day, that could take several years. Now this is minus COVID, of course. COVID has kind of tweaked this a little bit, but pre-COVID, you could get your lien trials on calendar within 30 days of a CNR. I mean, the requirements to file the liens now are immediate. You can't just sit on a, you know, they can't push you off for 2 or 3 years to resolve your liens. You can file your DOR immediately after CNR, and the boards will issue a hearing date within 90 days. So you're getting paid quicker. I mean, that's kind of the point, right? This whole reform thing was to mitigate legal costs to the insurance companies, get medical providers paid. And the way you do that is you set up guidelines that move these cases quicker, more stringent treatment guidelines so you don't overtreat, which means cases settle faster, right?
Lester, can I ask you something?
Sure.
Do you have any sense about case statuses, generally speaking, in terms of are you know, many cases falling within the 90 days period? Or
in terms of denying or accepting?
Yeah. So what's your experience?
So again, pre-COVID, right? COVID's kind of tweaked a lot of things. Everything's kind of getting, you know, extended farther. Most of these cases the insurance companies will take the full 90 days before they issue a response, okay? Part of the benefit, I think, to the insurance companies, and this is just my opinion, I don't know that there's any legal, you know, any factual data to support this, but we see so many cases here. Getting that patient that first $10,000 worth of care almost always will get the patient released back to work, right? Or will help determine the extent of the patient's injury so settlement can happen quicker. Where before, they would just deny everything and run it out because insurance companies don't want to spend money, right? But now that they're required to provide $10,000 worth of care anyway, right? Or accept the liability or deny it quickly. They don't want to deny fast because then that exposes them to much more liability down the line. They could, you know, be fined $10,000 in penalties for denying a claim that should have been accepted, blah, blah, blah. There's a lot of reasons behind it. They'll take the full 90 days, which means the primary doctors on these cases are probably going to get that full $10,000 in benefits before they accept or deny the claim. That's another really good reason to get back into this space. Because it's almost...
It's like a $10,000 med pay. Like
yeah, it's equivalent to med pay, but and in med pay PI cases, typically it's what, $2,500, $5,000 if you got a really, really good policy, right? So you're getting double almost, right, in workers' comp. So there's a lot of factors, but I think it's helped the industry. Again, this blueprint it's just easy to follow. If you follow the blueprint, you're going to get paid. Now, how much you get paid is determinative on quality of case, you know, whether it was accepted, you know, whether you're in the managed physician network. There's factors, but we deal with all of those. We address those. We educate on those, and it's a very easy system to follow when you've got somebody with knowledge guiding you, right? So
I'm looking at a couple other questions, so I don't want to wrap up without answering people's questions. This is from Lalit. It says, hi, everyone. Thank you for the webinar. When you say the employer has to provide a claim form once they learn about an injury, is the employer required to do that? What happens if they don't? Yes, they are required to do that. But if they don't and they know about the injury, it's the same as if they were provided a claim form. Typically, what I say is if the applicant doesn't come into your office with a claim form or you aren't provided with one by the attorney, you can always give the client the claim form. You can fill it, you can help them fill it out and sign it and then tell them, go give this to your employer. Now that dovetails nicely into the second question. The answer was you could lose medical control. Yeah, if they don't provide a claim form to the employee, the employee's just going to go out and get medical treatment. He may come to me, he may come into your office, and you're off to the races because they should have provided a claim form when they didn't. Now, the next question is, what if the client's concerned about getting in trouble by filing a work comp claim? What if the employee is concerned not to get the employer in trouble by filing a work comp claim? What can we advise the client as any detriment or lack thereof to the employer, i.e. insurance premiums going up? I don't think there's really much that you can do about preventing detriment to an employer by filing of a workers' compensation claim, other than if he doesn't file the claim and he continues to work with an injury, what are the chances of the injury getting worse or exacerbated by continuing to work, especially if the applicant, in this case, is required to do heavy repetitive work? You've got a bad shoulder and you continue to do work and it just gets torn, or the knee, it gets worse, so is it prolonging or, kicking a can down the road that ends up becoming not a can, but,
the liability is way worse if they don't, right?
Right.
So can you answer the insurance premium question from not only knowing it, but also from being an employer? I have quite a few employees, and
right.
Obviously we have work comp insurance, and, we're a clerical type business in the eyes of the work comp carriers. So everybody gets an insurance rating when you apply for it. They give you a rating depending on your historical, claims file, blah, blah. We've had quite a few. California is just known for employees filing work comp claims for various reasons. Obviously, the legitimate reasons is they got hurt on the job. They need to file a work comp claim, no question. Sometimes it's they got terminated and then all of a sudden they remembered for the last 6 months, they've been having shoulder pain. It's a work comp injury, whatever the case may be. The insurance premiums are very minorly affected. I mean, you got to have a lot of claims and high value claims filed against you for your premiums to really be affected, right?
But Basil, that's important to discuss about being a responsible reporting physician too, right?
Yep.
We do have a bad reputation in California of having practitioners on my side and doctors on your side. The doctors will treat whatever that, referral source, if it's a big referring attorney, sends tons of business your way, and, the person blows on a mirror and it fogs the glass. Okay, you're there, you can breathe, you're qualified. No. Don't get into this business with that in mind. Please be a responsible doctor. I mean, that's what you got into medicine for. If there's not an injury, I'm okay with you telling me, hey, or it comes back, it just needs a little bit of therapy and boom, it's a 0% impairment. That's okay. We can deal with that. I'd rather have that in many cases than having an over-treated, over-reported on nothing injury. You get discredited and I get discredited. And I don't know how anybody else feels about that, but that's my personal practice.
I completely agree with that.
Yeah, here's something we haven't really touched on. Pre-SB 863, every doctor who was treating work comp was like starving for patients. There was such a saturated market, that they would take any case. We're in a situation now, which again is one of the reasons we're having this seminar, is we're trying to get doctors back in, is there's a limited number of doctors that are treating work comp cases, right? So these doctors now can be very picky about.
They are picky, Basil.
Right?
Yeah.
And the attorneys don't get mad anymore, right? Attorneys used to say, take them all or you get nothing. Well, the attorneys right now are kind of in a situation where they don't really get to make that decision because there's only a handful of doctors that will take any work comp, right?
Right.
They're not going to take the bad ones, but you still need them to take the good ones. So again, another reason, a good opportunity to get back into this space is you're going to see that you will have the opportunity to pick and choose the quality of the cases you want to take without having to worry about burning that attorney source, right? That's kind of important, because that was a big thing back in the day. It was like everybody's, clamoring for patients, and it was just it was ugly. Those days are gone,
But SB 863 really streamlined a lot of stuff. I know people have been kind of up in arms about it. Frankly, the only reason that I stopped taking comp is because from MRI perspective and the lien filing fee perspective, financially it didn't make any sense. If I was a treating physician, I would be totally full board.
Listen, the treating doctors that I represent, and I represent a decent amount, we see quite a few new patients a month in my network. Their revenue has actually gone up about 20% post SB 863.
Oh, for sure.
Seeing less patients.
Yeah.
Seeing less patients.
Yeah.
Right?
Yeah. Yeah.
It's been really, really good for the doctors that are in it. The problem is like, I've got a client that has 3 clinics. They're maxed out. They can't see any more patients, right? So now there's patients that are good quality cases that are just not getting care because the doctors are too busy, right? Or they're not going to get good quality care because the doctors are going to slam them through, which we don't want, right? We want good quality care, return everybody back to work. We want to keep the industry healthy. That's the goal.
Any other questions that we need to, or information where we're at with this, Basil? I think we've, at least, hopefully we've whet your appetite for more. You maybe go to a CSEMS webinar or pay, I forget what the non-association fee is for a 3-day cost seminar, but the upside to going to a cost seminar is that you're going to meet 1,000 work comp attorneys. And it used to be back in the day that there was, and there's a vendor area where you can meet and greet and talk to people and shake.
I'm one of those vendors.
Right? you shake hands with your elbow now and you meet these attorneys. Now, right now it's virtual. Unfortunately, we don't have the big convention, which is kind of a bummer in that you don't get that personal one-on-one, but you can make those at least introductions and see people and put your name out there, and being part of those organizations are really going to go a long way in meeting the right attorneys, the right referral sources, and ingratiating yourself into the system. And it's a great learning process.
So Tom, this is a great time to learn when everything opens up and we can start meeting each other again in these conferences.
Yes.
Wouldn't it be great to have gotten these, the doctors 6 months, 8 months of education already, so when they're there with you guys, that they're able to speak the language with you and talk the lingo,
yes.
right?
Yes.
And so yeah, again, I'm going to put a plug in for CSIMS again. If you're not a member of CSIMS, I highly recommend that you join us. You're going to get tons of education. That's what we focused on. I'm sorry, I'm taking the time to plug CSIMS, but I think it's very important that, like Tom was saying, we join the right organizations, learn from them, people that have been doing this for the last 20, 25 years and have evolved with it. That's very important, right? There's been an evolution, Basil, right? Dr. Amin, right? Yeah, Dr.
Yes, correct.
An evolution, right? From
Yes.
2005, when we had SB 899 to SB 863 to SB 1160, right? So there has been an evolution. And so
there's been a lot of learning as well.
Absolutely. And those that have evolved with it, learn from them, because we have been able to, we can totally streamline this. One of the best times to be in comp would be right now if you want to start. Honestly, I'm not trying to fluff it. I don't need to. But come to CSIMS.
Can we ask Audrey a question? Audrey, are you going to circulate our emails to every one of the attendees? So if they've got questions, or they want to have any more in-depth conversation, or even engage us for anything else?
Yes, of course. I will give them all that information. If anyone wants to reach out for any of these lovely panelists, of course, Dr. Sana-Khan, Dr. Nia, thank you for joining us, and Basil and Tom, thank you so much. So you can always message me at events.dm injuryinstitute.com for any of their information. I'll send you all that goody knowledge.
Thank you for
So-
putting it together, Audrey. I know this is not easy stuff. It takes a lot of work.
Thank you.
So,
Sure.
Injury Institute, thank you very much. And we'll kind of push
Yep.
Thank you again, and thank
Thank you
you
all.
everyone for joining us.
Thank you all.
Well, take care.
Bye.
Bye.
Bye-bye.